Good evening, beautiful people. Thank you for joining us this evening. I hope you're having a fantastic day and week. Welcome to our weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. The final report of the first in the nation California Reparations Task Force is one of, if not the, most important government reports about the Black American community since the 1960s. Equally important, it's also the foundation for current and future reparations legislation in California. The California Reparations Task Force worked for 2 years creating this report that documents historical atrocities against the descendant community across California and the United States. The report is nearly 1,100 pages long, and we're bringing you every page of it, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. The task force made nearly 120 policy recommendations detailed in this final report. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California, CJEC. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California state prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now I ask you to do 3 things. Like this video, hit the bell for reminders, and subscribe to our YouTube channel. After we're done reading tonight, I'll ask you to do 3 more things. Get connected. Follow CJEC on all social media: Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. They are a 501c3 organization. To learn more about them, visit www.cabwhp.org. By way of introduction, my name is Raphael H. Plunkett. I live in Southern California. I'm originally from Chicago. And I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. The agenda for today, a continuation of Chapter 15 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight is Examples of Other Reparatory Efforts. We continue on page 556, which is part of Section 2, International Reparatory Efforts. South Africa continued. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website at www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch and listen to their readings of the first report on their YouTube channel at ETM Media Group, and on our website at www.cjec-official.org/videos. Second, today's sponsors are my 6 grandchildren, Marshall, Takumi, Madison, Marchand, Wataru, and Mallory Plunkett. I, Raphael H. Plunkett, volunteer with CJEC for my ancestors, my elders, myself, my children, my grandchildren, and my community. Third, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward in 2024. To read the bill, visit www.cjec-official.org/advocacy. Fourth, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During the 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So, to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Last but not least, a special thanks to CJEC's Reparations Organizing and Mobilizing Team, specifically our volunteer final report readers. I personally extend gratitude to Chris Lodgson for his focus and leadership. And without further ado, Chapter 15, Part 2 of the California Reparations Task Force Final Report. The Committee on Human Rights Violations, CHRV. The Commission's CHRV was responsible for investigating human rights abuses. One significant limit set on the work of the CHRV was that it could only investigate gross violations of human rights defined as killing, abduction, torture, and severe ill treatment that were politically motivated and which occurred between 1960 and 1994. This definition of gross human rights violations meant that forced removals to unfertile land, wholesale appropriation of land that left the majority of the population living on 13% of the land, oppressive labor conditions in mines and on farms, educational deprivations, and legal restrictions from birth to death would not be investigated. Nor would any of the racially based abuses that occurred before 1960 be included. Also excluded from investigation were practices that excluded Black South Africans from educational institutions and professions or restricted access to resources based on race. The Act also required a victim's claim of gross human rights violations to be corroborated before the victim could qualify for reparations. There was a documented massive document destruction campaign revealed during the reparations process, however, which likely affected the ability of many victims to obtain corroborating evidence of human rights abuses they suffered. Further, there were outside critiques that the requirement for corroboration, quote, placed an insurmountable burden on many individuals who lacked supporting evidence of their experiences of being tortured, kidnapped, or losing loved ones, end quote. With these limitations, the CHRV displaced, quote, specially trained statement takers, end quote, to all parts of the nation to take statements of victims. From the thousands of statements they received, several, quote, individuals whose stories would shed light on the broader patterns of abuses, end quote, were asked to tell their stories during televised hearings held throughout the country between 1996 and 1997. Of the three committees, the CHRV's work is the most well-known because of the televised hearings showcasing the victims' stories. Once a claim was filed, an investigation was conducted to determine whether there was enough to corroborate that the individual was a victim of gross human rights violations. If the claim was corroborated, the victim received a letter confirming their status as a, quote, victim, end quote, of human rights abuses. If the claim could not be corroborated, the person was also informed by letter and notified of their right to appeal the decision. Ultimately, 22,000 individuals were identified as victims of gross human rights violations. Amnesty Committee, AC. Several clauses in the Act guaranteed amnesty, that is, immunity from criminal and civil liability, for perpetrators of gross human rights violations, which included individuals and the state itself. Perpetrators of human rights abuses and/or violations could apply for amnesty for acts associated with a political objective in the course of the conflicts of the past, as long as they made full disclosure of all relevant facts. They did not have to express regret or remorse or offer an apology or request forgiveness to be granted amnesty. Ultimately, the Commission granted amnesty to approximately 1,200 individuals, turning down 5,000. If amnesty was granted, that meant a victim of the gross human rights violation could not pursue civil or criminal remedies against the perpetrator for the harms suffered. Instead, the victims had to rely on the new government for reparations. 6 months after the Commission began its work, 3 widows of victims of the security forces and the Azanian People's Organization, AZAPO, challenged the constitutionality of the act based on the amnesty provisions, which absolved the individuals and the state from civil and criminal liability for the human rights violations committed during apartheid. The Constitutional Court held that the act was constitutional despite the amnesty provisions because the amnesty provisions made it possible for, quote, the truth of human rights violations to be known and the cause of reconciliation and reconstruction to be furthered, end quote. The state authorized, quote, Parliament to balance the rights of victims against the broad reconstructive goals of the Constitution, end quote. The Committee on Reparations and Rehabilitation, CRR. The Commission's CRR was responsible for developing both the Urgent Interim Reparations Policy Program, UIR, and making final reparations policy recommendations to the President. The policy recommendations for the Urgent Interim Reparations Policy were to be implemented during the life of the CRR, and the CRR would be responsible for implementing those recommendations. The CRR was also responsible for determining which individuals qualified as victims under the Act's definition. This obligation required it to review referrals from both the CHRV and the Amnesty Committee and, quote, make recommendations in an endeavor to restore the human and civil dignity of such victim, end quote. The work of the CRR ended once the final reparations policy recommendations were submitted to the President. Development and implementation of the UIR program. The UIR was an interim financial reparations program. CRR sent UIR policy recommendations to the government in September of 1996. The government did not pass regulations to implement the UIR until April 1998. The UIR regulations required information and referrals to services and financial assistance to access services that were necessary to meet urgent medical, emotional, educational, material, and symbolic needs be provided to applicants whose needs the CRR deemed urgent. Those applicants whose needs were deemed urgent included individuals who were terminally ill and would not survive beyond the term of the commission, had no fixed home or shelter, were orphaned because of the violation, had physical impairments that markedly affected their social functioning, required special education because of mental or physical disability. The UIR payments were calculated based on need and the number of dependents the person supported, ranging from a maximum of R$2,000 or US $250 for a victim with no dependents to a maximum of R$5705 or US $713 for beneficiaries with 5 or more dependents. The regulations prohibited UIR funds from being transferred or ceded by victims. Further, the proceeds could not be attached as part of a court judgment or passed to the victim's estate. The first UIR payments were made in July 1998. The UIR, quote, process was mostly completed in April 2001, end quote. The President's Fund paid out about R$44 million or US $5.5 million in cash payments to 14,000 victims for 3 years. Those payments ranged from R$2,000 or US $250 to R$5,600 or US $700. The reactions of the beneficiaries who received reparations under the UIR program were mixed. None of the beneficiaries considered the reparations, quote, blood money, end quote, that was used to buy their silence. Some of the victims interpreted the funds not as compensation for the harm suffered, but as a symbolic gesture acknowledging their suffering. Others felt the compensation was inadequate to meet, quote, the tangible challenges of daily suffering, end quote, they experienced because of apartheid. This group believed the UIR, even as a symbolic gesture, was inadequate. The recipients of UIR also were sometimes threatened by those who did not receive UIR payments. Some critics of the UIR program contended that one inadequacy of the program was the lack of information shared with victims about the commission. Specifically, victims were not given information about how the commission was organized or how it functioned. Thus, they were not empowered to engage with the commission, nor were they knowledgeable about the next steps in the reparations process. And they received little information regarding the perpetrators the Amnesty Committee was considering for amnesty. One evaluation of the UIR program concluded that it, quote, has not made a meaningful or substantial impact on the lives of recipients and cannot, therefore, be considered a significant or even adequate attempt at reparations, end quote. Another critique was that the process for determining who would receive payments and providing payments to those individuals who qualified under the UIR took longer than expected. Although the CRR sent recommendations to the government in September 1996, the government did not pass regulations until April 1998, more than a year later. The government's delay in passing regulations caused the CRR to abandon the step in the process that called for the formation of a body that would coordinate and disburse the UIR reparations benefits. The CRR assumed those duties instead. Final reparations policy recommendations. The CRR was also responsible for developing final reparations policies recommendations that were submitted to the President for review. Once the final recommendations were submitted to the President would review them and submit a set of policy proposals, including some of his own, to the Parliament for debate. After a debate, the Parliament would pass a resolution approving the reparations policy recommendations. Once the parliamentary resolution was passed, the President was required to, quote, publish the appropriate regulations to enact the resolution, end quote. The regulations determined the basis and conditions upon which reparations would be granted and the authority responsible for implementing them. The regulations also provided for revision, discontinuance, or reduction of reparations where the President deemed fit to ensure the efficient application of the regulations. In creating its reparation policy recommendations, the CRR could consider all forms of reparations, including financial, symbolic, and community-wide benefits. The CRR could also make recommendations for the, quote, creation of institutions conducive to a stable and fair society and the institutional, administrative, and legislative measures which should be taken or introduced in order to prevent the commission of violations of human rights, end quote. In developing its proposals, the CRR turned to international sources and structured its policies around the 5 international reparations principles: redress, restitution, rehabilitation, restoration of dignity, and reassurance of non-recurrence. Once it defined the principles that would serve as the foundation for its reparations recommendations, the CRR began a consultative process with individuals, victim advocacy groups, NGOs, churches, civil society, and human rights organizations to develop a final reparations policy. The final reparations policy the CRR submitted to the President observed that, quote, without adequate reparation and rehabilitation measures, there can be no healing or reconciliation, end quote. More specifically, reparations were, quote, necessary to counterbalance amnesty, quote, given the perpetrators. The CRR reminded the government that reparations were a moral requirement for the transition out of apartheid and that moral obligation required substantial reparation grants, not token awards to victims. Granting reparations to the victims added value to the truth-seeking process by enabling survivors to experience the state's acknowledgement of the harm victims, their families, and South Africa as a whole experienced from apartheid. Reparations also restored the survivors' dignity and affirmed the values, interests, aspirations, and rights of those who suffered. Just as important, granting reparations also raised consciousness about the public's moral responsibility to participate in healing survivors and facilitating nation building. The Commission, through the work of its committees, identified 22,000 victims. Although victim advocates urged the CRR to keep the list of victims open so that victims who came forward later could qualify for reparations, it declined to do so for two reasons. It concluded that the government was unlikely to accept an open-ended list, and the CRR was without power to expand the definition of a victim under the language of the Act, to expand the list of people who qualified as victims beyond the 22,000 identified victims. The CRR made the following final reparations policy recommendations. Individual reparations cash grants. The CRR recommended that the government pay annual payments ranging between R23,023, that's $2,878 in US dollars, and R17,029, that's $2,129 US dollars, based on the size of the family for 6 years. The amount of the grants was based on the median annual household income for a family of 5 in South Africa, which was R21,700 or $2,713 US dollars in 1997. People in rural communities or with large numbers of dependents would receive more. Despite the CRR's justification for its reparations grants recommendation, the government rejected its recommendations and decided to give victims a one-time payment of R30,000, the equivalent of $4,000 US dollars each. The financial costs for the reparation grants of R30,000 amounted to 0.067% of gross domestic product, GDP, and 0.25% of the government's total annual expenditure. The CRR's policy recommendations also included several alternative schemes for financing the reparations grants: imposing a wealth tax, imposing a one-off levy on corporate and private income, requiring each company on the Johannesburg Stock Exchange to make a one-off donation of 1% of its market capitalization, levying a retrospective surcharge on corporate profits, imposing a surcharge on, quote, golden handshakes, end quote, given to senior public servants since 1990, and suspending taxes on land and other material donations to formerly disadvantaged communities. Recommendations for broader macroeconomic reforms. As a broader restructuring of macroeconomic policies for the country, the CRR made the following recommendations: reallocation of resources from the Defense Force budget, donations from individuals, international aid organizations, and the business sector. Request that the EU divert unspent funds earmarked for development projects into the President's Fund. Exert pressure on Swiss and other governments and banks for contributions. Restructure social spending limits, the tax system, and the government pension fund to release more money for social spending, and cancellation of foreign debt. One organization recommended that multinational corporations, which extracted roughly $3 billion a year between 1985 and 1993 from South Africa, be required to return 1.5% of those profits for 6 years, which would pay for the individual reparation grants. Recommendations for symbolic reparation and community rehabilitation. In addition to the individual reparation grants, the CRR recommended symbolic, community, and national reparation and rehabilitation policy proposals. The symbolic measures fell into 3 categories: individual interventions, issuing death certificates, exhumations, reburial ceremonies, headstones and tombstones, declarations of death, expungement of criminal records, acceleration of outstanding legal matters related to human rights violations. Community interventions: renaming streets and facilities, memorials and monuments, culturally appropriate ceremonies, national interventions, renaming of public facilities, monuments and memorials, a national day of remembrance. The community rehabilitation recommendations focused on programs and remedies that would address the harm caused to communities by apartheid policies. National demilitarization, resettlement of displaced persons and communities, construction of appropriate local treatment centers, rehabilitation of perpetrators and their families, support for mental health services and community-based victim support groups, skills training, specialized trauma counseling services, family-based therapy, educational reform at the national level, study bursaries, monetary education awards, building and improvement of schools, provision of housing. The CRR also recommended several proposals aimed at transforming institutions and a wide range of sectors in South African society, including the judiciary, media, security forces, business, education, and correctional services to prevent the recurrence of human rights violations that characterized the apartheid. The CRR had no power to implement any of these recommendations in its final reparations policy proposal because its term ended with the submission of the Commission's final report. Recognizing that the implementation would need to be organized at the national and local levels, the CRR recommended that the President appoint a secretariat with a fixed term to oversee the implementation of the reparations and rehabilitation proposals. The CRR also recommended the appointment of a national body headed by a national director to implement the reparations scheme. Among its duties, the national body would be responsible for implementing and administering any financial reparations policy, monitoring and evaluating the implementation of the reparations policies, and establishing provincial reparations desks to implement reparations policies at the local level. The provincial reparations desks would report directly to the national director. Government implementation. After the CRR submitted its final reparations policy recommendations, a core group of NGOs and victim advocacy groups emerged as leaders in the fight to ensure that the government implemented the final reparations policy recommendations implemented. The government resisted their efforts, however, on the grounds that not all of the Commission's work was completed, and until the Commission's final report was submitted, the government was not in a position to do anything with reparations. The final report was submitted in 2003. In late 2002, before the Commission's final report was submitted, several individual victims and victim advocacy groups filed lawsuits in a U.S. federal district court under the Alien Tort Statute against several multinational corporations that conducted business with South Africa during apartheid and manufactured products that helped the South African government maintain apartheid. In the end, the government did not adopt CRR's recommendations to appoint a secretariat to oversee reparations, nor did it appoint a national implementing body. It also did not adopt the recommendations for the government to pay individual reparations grants to victims for 6 years. Instead, in November of 2003, 5 years after the CRR submitted its reparations policy recommendations, the government began paying victims a one-time payment of R$30,000, the equivalent of $4,000 US. A year later, about 10% of victims had not received payment because there was difficulty in locating them or confirming bank account information. The total individual reparations grants paid to victims amounted to 1/5 of the CRR's original financial reparations recommendation. The government did enact some of the symbolic reforms and institutional reform recommendations. The government provided around $800,000 in reburial expenses to 47 families of disappeared persons whose remains were found and reburied. Public symbols of martyrs and those opposed to apartheid have replaced those public symbols of apartheid. The country's largest airport is no longer named after the first apartheid prime minister, and institutions have been integrated even if tensions remain. Much has been done for community rehabilitation in terms of housing, education, and access to health care. Quote, "There is still much to do," end quote, to ensure equity for Black South Africans in these areas of basic human needs, however. As of 2013, the President's fund stands at around 1 billion rand. The government has proposed to use part of this for medical and higher education assistance to the same registered victims who received compensation previously. It is also proposed to fund, quote, "community rehabilitation projects," end quote, in economically distressed communities. Victims and survivors have criticized both policies and have argued that medical and higher education assistance should be given as well as to an additional 30,000 more survivors who, for various reasons, were not able to register with the Commission during its tenure. These organizations have asked that individual compensation get equal priority over community reparations, and that the selection of communities for the latter program should be done in consultation with survivors' organizations. Throughout the life of the Commission and after, victims raised the objection that the Commission and the government have been much more interested in placating and protecting perpetrators than they have been in meeting the needs of the victims. Another key critique of the South African reparations process was that there was no institutional support for victims after the final reparations policy recommendations were submitted to the government, because the Commission formally ended the submission of its final report. Quote, "The failure to plan beyond the recommendations, however, resulted in many disappointed South Africans who assumed that meaningful reparations would begin at or before the close of the TRC process. Now that the TRC has formally shut down, the victims are left with their own meager resources and without any significant institutional support." End quote. The structure of the Commission, including the limitations placed on its power to implement its reparations policy recommendations, or even be involved in the process after submitting its recommendations to the President, almost guaranteed that the victims would not receive reparations based on the final reparations policy recommendations. Some scholars believe the problem with the implementation of the reparations scheme began with the secret negotiations to end apartheid and carried through the Constitutional Court's decision in the Azapo case that the amnesty provisions were legitimate even if they stripped victims of remedies for actual harm suffered. From the inception of the negotiations to end apartheid, there was no guarantee that victims would receive an adequate remedy of compensation. Although reparations were discussed at points during the negotiation process, a reparations policy that entitled victims to reparations was not codified in any of the official documents of the new government. Indeed, the act allowed the president to discontinue reparations if the president deemed it necessary to do so. A perpetrator's entitlement to amnesty, however, was guaranteed by the interim constitution, the final constitution, the act, and the Constitutional Court. In 1948, Universal Declaration of Human Rights asserted that an effective remedy should be provided for violations of fundamental human rights. Quote, "In this context, reparations have come to mean much more than a means of support or a kind of recognition of suffering. They have become the unfulfilled answer to the question of whether or not justice has been done in the transition process." End quote. Canada. The Canadian federal government entered into the Indian Residential School Settlement Agreement in September of 2007. It acknowledged the damage Canada inflicted on its indigenous peoples through the residential school system and established a multi-billion-dollar fund to assist former students of residential schools in their recovery. It has 5 main components: the Common Experience Payment, Independent Assessment Process, the Truth and Reconciliation Commission, Commemoration, and Health and Healing Services. The settlement agreement allocated $1.9 billion to the Common Experience Payment for all former students of the residential schools. Every former student was given $10,000 for the first year at school and $3,000 for each additional year. Indigenous children in Canada were sent to residential schools from the 17th century until the late 1990s. First established by Roman Catholic and Protestant churches and based on racial, cultural, and spiritual superiority, residential schools were an attempt to separate indigenous children from their traditional cultures and convert them to Christianity. The passage of the Indian Act in 1876 formally gave the federal government the power to educate and assimilate indigenous people in Canada, and the Act's further amendment in 1894 made attendance at residential schools mandatory. Starting in the 1880s, the Canadian government made a concerted effort to establish and expand the residential school system to assimilate Indigenous peoples into settler society and to reduce Indigenous dependence on public assistance. There were 130 residential schools in Canada between 1831 and 1996. During this time, more than 150,000 First Nations, Métis, and Inuit children were forced to attend these schools. Thousands of Indigenous children died at school or as a result of their experiences in school, while many remain missing. Children were forced to leave their homes, parents, and some of their siblings, as the schools were segregated based on gender. Their culture was disparaged from the moment they arrived at school. Children surrendered their traditional clothes and had to wear new uniforms. The boys had their hair cut, and many were given new names. At some schools, children were banned from speaking their first language, even in letters home to their parents. The Christian missionary staff at these schools emphasized Christian traditions while they also simultaneously denigrated indigenous spiritual traditions. Physical and sexual abuse were common. Many children were underfed, and malnutrition and poor living conditions led to preventable diseases such as tuberculosis and influenza. Daniel Kennedy, a former student at Coppell, recounted his experience. In 1886, at the age of 12 years, I was lassoed, roped, and taken to the government school at Le Bret. 6 months after I enrolled, I discovered to my chagrin that I had lost my name. An English name had been tagged on me in exchange. Quote, "When you were brought here," the school interpreter later told me, "for purposes of enrollment, you were asked to give your name, and when you did, the principal remarked that there were no letters in the alphabet to spell this little heathen's name, and no civilized tongue could pronounce it. We are going to civilize him, so we will give him a civilized name, and that was how you acquired this brand new white man's name." End quote. In keeping with the promise to civilize the little pagan, they went to work and cut off my braids, which incidentally, according to the Assiniboine traditional custom, was a token of mourning. The closer the relative, the closer the cut. After my haircut, I wondered in silence if my mother had died, as they had cut my hair close to the scalp. I looked in the mirror to see what I looked like. A Halloween pumpkin stared back at me, and that did it. If this was civilization, I didn't want any part of it. I ran away from school, but I was captured and brought back. I made 2 more attempts, but no better luck. Realizing that there was no escape, I resigned myself to the task of learning the 3 R's. Visualize for yourselves the difficulties encountered by an Indian boy who had never seen the inside of a house, who had lived in buffalo skin teepees in winter and summer, who grew up with a bow and arrow. Indigenous communities struggled to heal from the harm done by these residential schools, and starting in 1980, former students campaigned for the government and churches to acknowledge the abuses of this system and provide some compensation. A group of 27 former students filed a class action lawsuit, Blackwater v. Plint, against the Government of Canada and the United Church of Canada in 1996. Blackwater specifically pertained to the abuses perpetrated at Alberni Residential School on Vancouver Island in British Columbia. The lawsuit spanned 9 years, with the Supreme Court of Canada finally concluding that churches were not immune from damage claims and shared blame with the federal government. Thousands of former students began to sue the federal government and churches for inter alia, assault, negligence, breach of fiduciary duty, and vicarious liability. The sheer number of cases pending in the Canadian court system threatened to create a logjam, and the federal government in June of 2001, quote, convened a series of dialogues on the subject of developing alternative dispute mechanisms between representatives from the church organizations, the federal government, and Aboriginal peoples, leaders, and healers, end quote. The federal government issued a statement of reconciliation in 1998 that recognized the abuses of the residential school system and established the Aboriginal Healing Foundation. In 2001, the federal government created the Office of Indian Residential Schools Resolution Canada to manage the abuse claims filed by former students through the Alternative Dispute Resolution Process, ADR. In 2003, the ADR process began to provide psychological support and calculate compensation. The Indian Residential Schools Settlement Agreement was signed on May 8, 2006, and it went into effect in September 2007. It is the largest class action settlement agreement to date in Canadian history. On June 11, 2008, former Prime Minister Stephen Harper offered a public apology to those harmed by the residential schools. The leaders of the Liberal Party, the New Democratic Party, and the Bloc Québécois also made official apologies. As stated previously, under the settlement agreement, every former student was given $10,000 for the first year at school and $3,000 for each additional year. By the end of 2012, 98% of the 80,000 eligible former students received payments. The independent assessment process provided a mechanism to resolve sexual abuse claims as well as serious physical and psychological abuse claims. By the end of 2012, it provided more than $1.7 billion to former students. Survivors had to detail the abuse they faced at a hearing, such as the duration, the abuser's identities, and medical and personal information. This often led to reopening of old wounds. For both the common experience payment and the independent assessment process, rejections, inability to establish attendance at schools, failures of the process, and dismissal of claims led to re-traumatization of survivors and further harm. Additionally, the settlement agreement allowed attorneys to charge clients up to 15% for difficult cases seeking compensation before the independent assessment process. Unfortunately, some unethical private attorneys charge 15% in addition to further improper interest, fees, and penalties. The settlement agreement allocated $60 million to the Truth and Reconciliation Commission for 5 years so that individuals, families, and communities could tell their stories, and the commission held national events to bring public attention to the issue. The commission issued a report in December of 2015 entitled Honoring the Truth, Reconciling for the Future, that documented the experiences of the 150,000 survivors. In addition, the settlement agreement allocated $20 million for commemorative projects and $125 million for the Aboriginal Healing Foundation. It also established the Indian Residential Schools Resolution Health Support Program, which offers former students mental health resources provided by elders, indigenous community health workers, psychologists, and social workers. Residential schools continue to be in the news. In 2021, indigenous communities reported they uncovered hundreds of unmarked graves of children who possibly died at residential schools due to disease or neglect, or who were possibly even killed. The federal government responded by announcing in August of 2021 an additional $320 million, quote, for indigenous communities facing the fallout of the residential school system, end quote, for which $83 million, quote, will go toward burial site search efforts and commemoration for the victims, end quote. The federal agency responsible for indigenous relations will also create an advisory committee that includes experts in archaeology, forensics, and mental health as the grave searches continue. Canada's Minister of Justice will also appoint a special investigator to make recommendations about the grave sites and changes to federal law. These discoveries have led to a federal investigation of similar schools in the United States. Additionally, despite the settlement agreement, litigation has not stopped. In October 2022, the Canadian Supreme Court dismissed an appeal from a group of survivors from St. Anne's Residential School in Northern Ontario, who have alleged the former government breached the settlement agreement because, quote, it withheld documentation of abuse when deciding upon their compensation, end quote. In 2014, the Ontario Supreme Court ordered 12,300 pages of records, including transcripts of criminal trials, investigative reports from the Ontario Provincial Police, and civil proceedings about child abuse, be produced as part of the compensation process. The documents were heavily redacted, and survivors claimed the redactions made it impossible to determine adequate compensation. The Minister for Crown Indigenous Relations had stated the office will still discuss the case with St. Anne survivors and has pointed to a 2021 report that noted 11 compensation cases that could be eligible for further payments. In January of 2023, Canada stated it had agreed to pay $2.8 billion, quote, to settle the latest in a series of lawsuits seeking reparations, end quote, for the harm to Indigenous communities through the residential schools. This settlement is a resolution of a class action lawsuit initially filed by 325 First Nations in 2012, seeking compensation for the destruction of their language and culture. Under the terms of the settlement, the federal government will establish a trust fund for indigenous communities to use for educational, cultural, and language programs. Part 3. Domestic Reparatory Efforts. History of the movement for reparations for African Americans. The earliest calls for reparations for African Americans precede the Civil War, with enslaved people demanding compensation for their labor and bondage. In 1783, Belinda Sutton, a formerly enslaved woman in Massachusetts, petitioned the Massachusetts General Court for a pension from the estate of her enslaver, Isaac Royal, Jr. 50 years her faithful hands have been compelled to ignoble servitude for the benefit of an Isaac Royal. The face of your petitioner is now marked with the furrows of time, and her frame feebly bending under the oppression of years, while she, by the laws of the land, is denied the enjoyment of one morsel of that immense wealth, a part whereof hath been accumulated by her own industry, and the whole augmented by her servitude. Sutton's petition is one of the first narratives of African Americans demanding reparations. The court granted her petition, partially due to Royal's resistance to American independence and allegiance to the Tories. Calls for reparatory justice gained momentum at the end of the Civil War, after the federal government failed to fulfill General William T. Sherman's promise to give 40 acres and a mule to those who were formerly enslaved. African-American abolitionist Frederick Douglass demanded land distribution for the formerly enslaved, comparing their plight to the Russian serfs who received land grants following their emancipation. In the late 1800s, African-American freedmen led the call for reparations. Callie House and Isaiah Dickerson chartered the first national reparations organization, the National Ex-Slave Mutual Relief, Bounty, and Pension Association, MRBPA, in Nashville, Tennessee in 1898. The MRBPA grew to 300,000 members by 1916. Their mission included 1. Identifying the formerly enslaved and adding their names to the petition for a pension. 2. Lobbying Congress to provide pensions for the nation's estimated 1.9 million formerly enslaved, 21% of all African Americans by 1899. 3. Starting local chapters and providing members with financial assistance when they became incapacitated by illness. And 4. Providing a burial assistance payment when a member died. MRBPA's founders were inspired by the federal pension program for disabled veterans of the Civil War. MRBPA filed a lawsuit against the federal government on behalf of African American freedmen for $68 million, the value of the cotton that had been grown and harvested by enslaved persons and that had been confiscated by Confederates around the end of the Civil War. The claim was denied. The MRBPA faced strong opposition from the U.S. government. In 1916, the government indicted Callie House for fraud, claiming that the leaders of the MRBPA obtained money from the formerly enslaved by fraudulent circulars advertising that reparations from the government were forthcoming. House was convicted and served time in a penitentiary in Missouri. Another reparations trailblazer was Queen Mother Audley Moore, known as the, quote, mother, end quote, of the modern reparations movement. Moore founded several organizations, including the Committee for Reparations for Descendants of U.S. Slaves, dedicated to fighting for land and other reparations for African Americans. In 1957 and 1959, she formally petitioned the UN for reparations for African Americans. In 1968, Moore helped found the Republic of New Africa, an organization that advocated for the formation of a separate, majority black nation in the southeastern United States. Around the same time as Moore's UN petition and creation of the Republic of New Africa, many civil rights and black nationalist groups also demanded reparatory justice in addition to legal equality. For example, in the Black Panthers' 10-point program, they called for the, quote, end to the robbery by the white man of our black community, end quote, and demanded the debt owed of 40 acres and 2 mules. In a speech to students at Michigan State University in 1963, Malcolm X called for reparations. The greatest contribution to this country was that which was contributed by the black man. Now, when you see this, and then you stop and consider the wages that were kept back from millions of black people, not for 1 year, but for 310 years, you'll see how this country got so rich so fast. And that made the economy as strong as it is today. And all that labor, that slave labor that was amassed in unpaid wages, is due somebody today. In 1969, activist James Forman proclaimed a black manifesto that demanded $500 million from white Americans paid by churches and synagogues for their role in perpetrating slavery. The Black Manifesto resulted in donations of $500,000, which supported the establishment of several black political and economic associations, such as a black-owned bank, 4 television networks, and the Black Economic Research Center. The reparations movement surged in the 1980s. The National Coalition of Blacks for Reparations in America was founded in 1987. And, with its help, U.S. Representative John Conyers in 1989 introduced H.R. 40, a bill to establish the Commission to Study and Develop Reparation Proposals for African Americans. Representative Conyers introduced the bill 20 times without success. The publication of the 2014 essay, quote, "The Case for Reparations," end quote, by Ta-Nehisi Coates in The Atlantic 429, catalyzed the federal government to hold committee hearings to consider H.R. 40. In the summer of 2020, the murder of George Floyd by police in Minneapolis sparked racial justice protests across the country that further pushed demands for reparations to the forefront of the public conversation. Reparations became a topic in the 2020 Democratic presidential primary. In April 2021, with U.S. Representative Sheila Jackson Lee as the bill's present sponsor, H.R. 40 was voted out of the House Judiciary Committee for the first time, but failed to receive consideration by the full House of Representatives in the 117th Congress, 2021-22. H.R. 40 has been reintroduced in the 118th Congress, but as of May 2023, it is awaiting consideration by the House Judiciary Committee. In the absence of federal action, states, cities, and municipalities have taken calls for reparations into their own hands. Federal Reparatory Efforts, U.S. Indian Claims Commission. The United States Indian Claims Commission, or ICC, was established in 1946 through federal legislation. The commission provided a forum for Native Americans to pursue legal claims against the United States based on the government's appropriation of tribal land during the 18th and 19th centuries. Congress established the forum out of a recognition that treaties underlying many land transfers were inequitable. However, the commission was not empowered to transfer land back to tribes and instead made financial awards to successful claimants. Over the course of approximately 30 years, the commission resolved over 500 claims and awarded approximately $800 million to tribal claimants. The ICC was ostensibly established to redress the harms inflicted on Native populations during the United States campaign of colonization and relocation that began in the late 18th century. Government transgressions during this period were as diverse as they were devastating. They included not only a staggering dispossession of land, but also the widespread killing of Native Americans that many, including California Governor Gavin Newsom, have called a genocide. During this period, spurred by the doctrine of manifest destiny, the government acquired nearly 2 billion acres of land from indigenous peoples, leaving just 140 million acres under Native control. This dispossession was accomplished by various means, including outright conquest, treaty, executive order, and federal statute. Although the government's misconduct during this period was far-reaching, the ICC's focus was solely on land transactions, mostly notably in the treaty process. Many government leaders and historians have claimed that these transactions were fair and equitable, but others have recognized that they were a means to, quote, dismantle Native land ownership and codify its expropriation, end quote. The treaties were, quote, negotiated under duress or facilitated with bribes and often were violated soon after ratification, despite the language of perpetuity, end quote. Moreover, the Indian Removal Act of 1830 codified the federal policy of relocating Native Americans to make way for settlers, which left tribal landowners with a Hobson's choice: either sell their land via treaty or be forcibly removed without compensation. Those removals led to many atrocities, including the Trail of Tears, in which the forced migration of Cherokee and other native peoples led to the deaths of thousands of Native Americans from disease and starvation. Against the backdrop of these takings, tribes began to file legal claims in the U.S. courts in the early 19th century, but a succession of legal rulings and legislation precluded Native Americans from even having their claims heard. Small progress was made in 1881 when Congress passed a jurisdictional act granting the Choctaw tribe access to the United States Court of Claims. This theoretically made the legal process available to Native Americans, but any tribe seeking redress first needed individual congressional approval. By 1946, almost 200 tribal claims had been filed in the Court of Claims, but only 29 received awards, and most of the remaining claims had been dismissed for jurisdictional technicalities. Quote, "The government, the Indians, and impartial researchers all deemed this process to be inadequate," end quote. And the prevailing dissatisfaction led to the creation of the Indian Claims Commission. The commission was established with the goal of efficiently and conclusively resolving tribal claims against the United States government. It had jurisdiction to hear claims from, quote, "any identifiable group of Indian claimants residing in the United States or Alaska," end quote. Much of the debate leading up to the enacting legislation centered on whether the entity should be adversarial or investigatory, and also on what role, if any, Congress should play in resolving individual claims. It was ultimately decided that, though labeled a, quote, "commission," end quote, with investigatory powers, the ICC would also be a quasi-judicial and adversarial forum. The ICC was limited to awarding monetary relief and thus did not have jurisdiction to restore title to land. The authorizing legislation permitted various claims, including those premised on, quote, "fraud, duress, and unconscionable consideration," end quote, as well as those based on, quote, "fair and honorable dealings," end quote. The Congressional Committee on Indian Affairs stated that the bill was, quote, "primarily designed to right a continuing wrong to our Indian citizens for which no possible justification can be asserted," end quote. Indeed, the majority of claims alleged that, quote, "the United States acquired valuable land for unconscionably low prices in bargains struck between unequals," end quote. Another large swath of claims alleged that the government had failed to abide by treaty provisions and called for an historical accounting, including in instances where the government was alleged to have mismanaged tribal funds. The commission initially comprised 3 members, all appointed by President Harry Truman. It acted as a, quote, "quasi-judicial branch of the legislature," end quote, that considered voluminous documentary and testimonial evidence, rendered rulings on motions, and presided over trials. Claims could be filed only during the first 5 years of the commission. Neither the statute of limitations nor doctrine of lashes could be raised as a defense to tribal claims, but all other defenses were available to the government. In 1946, the Commission sent notice of the claims procedures to every recognized tribe within the United States. Native American tribes secured counsel of their choice, and the government was represented by the Attorney General. All land claims were divided into 3 phases: title, value, liability, and offsets. In the title phase, the Commission sought to identify the territorial boundaries that the tribe exclusively occupied. This phase frequently relied on the testimony of historians and anthropologists. If the tribe successfully established title, the Commission proceeded to determine whether the government bore any liability and, if so, for what amount. During this stage, expert appraisers valued the land as of the treaty date, and historical records were reviewed to determine the compensation originally paid. The award was calculated based on the difference between the fair market value and the original compensation. Lastly, the Commission deducted, quote, offsets, end quote, from any award based on, quote, all money or property given to or funds expended gratuitously for the benefit of the claimant, end quote. Adverse rulings could be appealed to the Court of Claims and, in certain instances, the United States Supreme Court. If a trial led to a financial award, the amount was certified and reported to Congress after all appeals were exhausted. The award was then automatically included in the next year's appropriation bill. Final payment was deposited in the Treasury, and Congress directed how it should be distributed. The ICC was initially set to terminate 10 years after its first meeting, but it was repeatedly extended until its termination in 1978. Individual cases often took several years to complete, and the appeal process alone typically took between 8 months and 3 years. During its tenure, the Commission adjudicated more than 500 claims and issued tribal awards in over 60% of matters. It awarded approximately $800 million in total compensation to tribal claimants. At its termination in 1978, the Commission had not fully cleared its docket, and the remaining matters were transferred to the Court of Claims. Historians and legal scholars have argued that the Commission did not go nearly far enough to address the centuries-long displacement and oppression of Native Americans. The Commission was not empowered to convey land back to tribes, yet its rulings have barred all subsequent claims, including those to repossess land. Nor did the Commission address issues such as the suppression of native languages, religion, and forms of government. And even where a tribe was able to secure a financial award, the amounts were significantly reduced in various ways. For example, awards were whittled down by offsets for monies purportedly spent by the government on behalf of the tribes. Moreover, except in the rare claim premised on a Fifth Amendment, quote, taking, end quote, the Commission ruled that interest on amounts owed was not recoverable. The unpaid interest on successful claims likely amounted to several $billions. Many historians have argued that a core defect in the ICC structure and practice was the adversarial rather than investigative nature of the proceedings. One scholar has observed that, quote, the Commission, submissive to the requests of the lawyers who practiced before it, has provided for a bewildering series of hearings on title, value offset, attorney's fees, and all the motions that any party chooses present. Moreover, the government's role as adversary against the claimants meant that government attorneys often aggressively fought against proper compensation for tribal claimants, and as a matter of policy, the Attorney General did not pursue settlement. Finally, the tribe's obligation to retain counsel at its own cost diminished any eventual financial award. In light of these and other inefficiencies, many have argued that the Commission should have operated as an investigative rather than quasi-judicial body. Indeed, the Commission was statutorily authorized to conduct its own investigations, but it rarely employed those powers and instead consistently acted as a tribunal. Despite its shortcomings, many contemporaneous political leaders and early historians pointed out to the ICC as proof that the United States had acted benevolently and had atoned for past transgressions. Some have called these claims mere sanctimony and have argued that the ICC was established out of the government's self-interest in cloaking itself with moral authority, especially in the context of the United States' efforts to establish the post-World War II Nuremberg trials. Others have similarly argued that the Commission was simply a means of efficiently disposing of the, quote, Indian problem, end quote. For example, Professor Harvey Rosenthal, author of a comprehensive history of the ICC, has observed that, quote, the Commission broke no new ground and was really a government measure to enhance its own efficiency by disposing of the old claims and terminating the Indian tribes, end quote. And that will conclude tonight's reading of Chapter 15 of the California Reparations Task Force's final report. We ended on page 569 today. Our next reading will resume with The Tuskegee Study of Untreated Syphilis in the Negro Male on page 569. That will happen on next Thursday at 7 p.m., and we hope you'll join us. You can listen to the recordings anytime. Please share this information with your family, friends, and colleagues. Before you go, if you haven't done so already, please remember to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, please remember to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, X, formerly known as Twitter, at CJECOfficial. Get informed. Visit us at www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved to support our work by volunteering and/or donating. To donate, click the Donate tab on the home page of our website. A special thank you goes out to our amazing fiscal sponsor, the California Black Women's Health Project. To learn more about them, go to www.cabwhp.org. Thank you all so very much for your time. I appreciate you all. Thank you again to today's sponsors, the Plunkett children, and to all of the listeners who have donated. We are closer to reparations than we have ever been in California. Thank you for your time. Have a great night.